As we know by now, between the mid-1980s and early 1990s, many politicians advocated a get tough response to crime. Policymakers were particularly concerned with controlling the behaviors of young urban African American males. In order to expand their control over minority males, legislators passed laws which lowered the minimum age that a youth could be transferred to the adult court. Also, legislators across the United States increased the types of offenses where a juvenile could be tried as an adult. Barry Feld, in the second edition of his book, Juvenile Justice Administration in a Nutshell, argues that during this time frame we saw a shift in discretion from the judicial branch to the executive branch of government. In other words, new statutes took the discretion away from judges and gave it to prosecutors instead. It was the prosecutor who in turn made important charging decisions which could determine whether or not a juvenile was tried in an adult court or in a juvenile court. Typically, 14 is the minimum age for a youth to be transferred to an adult court. However, Feld argues that some states permit the waiver of youths as young as 10. Other states do not specify a minimum age. This again will vary from state to state. However, it is something that we as criminal justice scholars should definitely be concerned with. Across the United States, thousands of children have been sentenced as adults and sent to adult prisons. Over 2,200 juveniles nationwide have been sentenced to life imprisonment without the possibility of parole. Children as young as 13 years old have been tried as adults and sentenced to spend the rest of their life in prison, typically without any consideration of their age or circumstances of the offense. In the United States, dozens of 13 and 14-year-old children have been sentenced to life imprisonment with no possibility of parole after being prosecuted as adults. While the United States Supreme Court recently declared in Roper v. Simmons that death by execution is unconstitutional for juveniles, young children continued to be in prison with very little scrutiny or review. Just for the record, the Roper case was a 5-4 decision. Prior to this landmark case, states within the U.S. had executed nearly 30 youths for crimes they had committed before they were 18 years of age. Most of the tough sentences imposed on these children tend to be mandatory. This is an example of the legislative offense exclusion that Feld alludes to in his book. Here, the court typically cannot give any consideration to a child's age or life history. Instead, it must do what the law requires. This again is an example of how discretion has left the hands of the fatherly benevolent judge and has moved instead to the legislator, who passes get-tough laws which he or she believes to be politically popular. Incidentally, many of the children who are tried in an adult court are often convicted for offenses where older teenagers or adults were involved and primarily responsible for the crime. And nearly 2/3 of these adolescents who have had their cases adjudicated in an adult court are children of color. Perhaps you remember reading Simon Singer's article titled Sentencing Juveniles to Life in Prison from a previous session. If you recall, in his article, Simon points to the fact that recently the U.S. Supreme Court has issued a historic ruling in Graham versus Florida that holds life without parole sentences for juveniles convicted of non-homicide offenses is unconstitutional. In the aftermath of this case, dozens of other juveniles sentenced to life without parole for non-homicidal offenses were entitled to relief. This, by the way, was a 6-3 decision. Let us look briefly at the case of Graham versus Florida. In his majority opinion, Justice Kennedy explained a categorical rule barring life imprisonment without parole sentences gives all juvenile non-homicide offenders a chance to demonstrate maturity and reform. The juvenile should not be deprived of the opportunity to achieve maturity of judgment and self-recognition of human worth and potential. Discussing Graham's case, the majority wrote, "The state has denied him any chance to later demonstrate that he is fit to rejoin society based solely on a non-homicide crime that he committed while he was a child in the eyes of the law. This, the Eighth Amendment does not permit." This is a significant victory for children. The court recognized that it is cruel to pass up final judgment on children who have an enormous capacity for change and rehabilitation compared to adults. Nevertheless, if a youngster commits a homicide, he or she can still be incarcerated for life. It is worth mentioning that the United States is currently the only country in the world where children can be sentenced to life in prison. In his book, Barry Feld argues that in addition to legislative offense exclusion, prosecutors can also initiate what is known as a direct file. In fact, Bernard and Kurlichek discussed this in their book, The Cycle of Juvenile Justice. Proponents of direct filing claim that prosecutors can be more neutral and objective than either soft judges or get-tough legislators. Of course, it is also possible that prosecutors may succumb to political pressures. What is interesting is that typically courts do not review prosecutors' charging decisions because constitutional separation of powers denies the judicial branch the power to compel or control discretionary decisions made by members of the executive branch. The only way that a court could challenge a prosecutor's decision to direct file would be if it could be shown that the prosecutor based his or her decision solely on an issue such as race, religion, or the like. This then would violate equal protection laws, and a court could possibly intervene. In addition to legislative offense exclusion and direct filing, there is also, of course, a judicial waiver. This is where the judge will have the ability to transfer a juvenile defendant to the adult court. In his book, Feld argues that even though judges conduct waiver hearings informally, these may still be adversarial in nature. Both the state and juvenile may submit evidence that is relevant to the decision, and they may cross-examine the testimony and submissions of the other party. Of course, this may vary from state to state. As Feld points out, state laws differ on the burden of proof and who bears it in waiver hearings. I suppose each of the above three strategies has its supporters and its critics. Feld goes into this in some detail in his book, and for the sake of brevity, I will not repeat all of the various arguments. Nevertheless, I would strongly urge you to familiarize yourself with each of the three processes by which juvenile defendants can be transferred to the adult court. And as you read through Feld's chapter on juvenile justice jurisdiction, ask yourself which of the above three strategies makes the most sense to you. The Justice Department estimates that about 10% of all homicides are committed by juveniles under the age of 18. Juvenile courts focus on rehabilitation, unlike adult jails and prisons, where criminals are subject to incarceration and much harsher sentences. Today, virtually every juvenile offender who has a past criminal history or is arrested for a violent crime like rape or murder is tried in an adult court. According to a recent report by the National Institute of Corrections, young offenders in the adult system face a higher risk of being assaulted and are more prone to suicide and are 34% more likely to commit crimes once released than are offenders processed in the juvenile system. And there are racial disparities in the type of adolescents who get sent to adult prisons. Research, the report says, has found that African American youths are 9 times more likely than whites to get an adult prison sentence. Data for Hispanic youth is less complete, according to the report, but research indicates that Hispanics are 43% more likely than white youth to be put into adult prison. Incidentally, according to a 2009 Bureau of Statistics report, the South by far incarcerates its youthful offenders at the highest rate within the United States. And the South incarcerates these youth in adult prisons at a higher rate than any other region, such as the Midwest, the Northeast, and so forth. In fact, after reading this report and doing some quick math, it appears as though the South incarcerates youth in adult facilities at a rate that is about 1.5 times that of all the other regions in the U.S. combined. This, I feel, is significant and is truly worthy of further investigation. Traditionally, juvenile courts have restricted access to records. This confidentiality is given in order to keep juveniles from being stigmatized later. Nevertheless, some jurisdictions will look at these records if a juvenile continues to offend into adulthood. In fact, as Feld points out, some states will use a juvenile's prior conviction record to enhance an adult sentence. So if a juvenile is waived to an adult court, in some states a judge can look at the defendant's juvenile record. This is based upon a philosophy that the state's interest punishing recidivists takes priority over sealing juvenile records. In fact, Feld contends that in the state of California, the 3-strike sentencing law includes juvenile adjudications as prior felony convictions for purposes of sentence enhancements. Many scholars would suggest that this policy is hardcore. What do you think about this policy? As you read through the second part of Feld's book, ask yourself what policymakers can do to bring about justice for juvenile defendants. For example, should juvenile defendants be entitled to a trial by jury, which they presently are not guaranteed in all the 50 states? Also, for example, should juvenile defendants have certain rights during police interrogation practices? Should it be mandatory, for example, for a juvenile who is taken into custody to consult with an attorney prior to being interrogated? And should there be a parent-child privilege similar to a husband-wife privilege? Currently, common law protects a spouse from having to testify against the defendant he or she is married to. Should all states extend this privilege to the parent-child relationship? For example, let us suppose that a child confides something to his or her parent. Should a prosecutor later be permitted to subpoena the parent in order to retrieve this piece of information? Consider this as well as other dilemmas as you read through the material for this discussion session. These are important questions to ask. On one hand, there's a societal need to put dangerous and habitual individuals in secure settings regardless of what their age is, but nevertheless, there are those who insist that juvenile justice must truly have a sense of justice, not only for the victims and society, but also for the accused as well.